Ebusianfo, say this is going to be the last video I'll do on the Constitutional Review Committee. But if I find anything interesting again about it, me de beba betuja. Now, my 2 videos already. One on what the Constitutional Review Committee is saying about the presidency. The other on what the Constitutional Review Committee is saying about the Parliament. And this third one is what the Constitutional Review Committee is saying about the judiciary, right? Let's just go into it. My answer is because on the mestre. Say what raw novdek and now wasi na results na nkoye. Opesa otro sats Gen Feb. Na opesa otro na opass ya. Me recommend this Sanctuary College amount. Now school way or Dansoman, they have hostel facilities. The only reason why I am recommending this school and they say obi biara wa register with school way biano e pass it with distinction. Frewomo it was 05377302272. I mean most subium 05377302272 and then talk to them. Anyway, let's go to the Constitutional Review Committee, what they are saying about the judiciary. For people who are watching this video for the very first time, because Ebia no be here for the very first time, we name the air course. My 2 videos already on this particular issue. Now, in Penyufu ewo Ghana Chrome Heart and Ase, kase constitution a ye use 1992 constitution no. Ache. In fact, President His Excellency John Dramani Mahama ena order Penyufu yi say omo entena se no form adwembom no mumbisa Ghana for no munhu de pese ye. Nti Penyufu etena se no munhu se dabi. Ye constitution no Ghana, your constitution no ache e wose yesesa nyama bi e wo constitution nim. Ti no na the Constitutional Review Committee. Nti omo se yesesa nyama bi e wo your judiciary side. Nti no na mebe kenkan ya ma obi ate ase. Also the jurisdiction of the Supreme Court. Also the committee recommends maintaining the existing jurisdictional structure of the Supreme Court. However, the committee recommends introducing measures to streamline its appellate workload. In particular, the committee recommends that appeals of cases from the lower courts should terminate at the Court of Appeal without an automatic right of appeal to the Supreme Court, unless by leave. This reform should reduce the court's the court's caseload, enhance the timeliness of its decisions, and allow it to focus on matters of substantial constitutional and national importance. Once again, so obi ni asem na ruling eba every high court na nipa baako asem na anye ne da obetumi de akọ appeals court or the kokodu appeals court na eno nso anye obi da. The next point ene say ye de ko Supreme Court omotra cases bi say no ena ama Supreme Court eya na cases bebre wo ho a wo ntumi ndi nwie enti ye make sure say cases bi sa no ebe ende ewo appeals court. Appeals court the rule in eba a ende wo ho untumi mfa mba Supreme Court biom, so that Supreme Court benya mre na omo concentrate on cases a year of national importance, cases a ehia Ghana, right? No. Also in line with the committee's also size of the Supreme Court and other superior courts. In line with the committee's earlier recommendation to streamline the appellate jurisdiction of the Supreme Court, thereby reducing its workload, the committee proposes the following constitutional reforms. Also amend Article 1281 to provide that the Supreme Court shall consist of the Chief Justice and not more than 14 justices. The prescription of an upper limit will preserve appointment flexibility while safeguarding against excessive expansion of the courts. And you say Supreme Court judges and 14 plus the Chief Justice making 15. My judge be a man meka ho. It will amount to excessive expansion of the courts. I say there should be no numerical cap imposed on the Court of Appeal in the High Court to allow for periodic adjustments in their composition in response to population growth, increased caseloads, and evolving demands of justice delivery. Now, so High Court, any a year a court of appeal there. My yɛmfa number bi anto so ɛne deɛ judges ebetumi de ato hɔ no yɛmfa mo nto wo bebree na mo nyinaa ndidi case. But Supreme Court there, just 15 judges and I was a war. Also, qualification and appointment of Chief Justice and other justices of the Superior Court. The committee recommends a revised appointment framework, incorporating processes such as advertisement of vacancies, defined merit benchmarks, judicial council scorecards, application to the Judicial Council, as well as public vetting. Inti se ye pese ye selected Chief Justice. Ye mo obi ba be Chief Justice a. Ye nsesa no. Once the first ye pese ye selected Chief Justice, the president no na or be choose obi say we na me pese oba be than Chief Justice na nipa ko na ya select no. Ye nsesa no. Ye making sure say ye create framework bi. Framework no, it will be made up of say ye be advertise the vacancy. Ye pese ye de obi babe than Chief Justice and a judge of a superior court sir. E was say advertise say oh e kwanya babe that Supreme Court ye pese obi a woji ne hu de say wo betumi adani a Supreme Court judge no ombra. Yema merit benchmark. Say ye hwe say obi a pese ye select no say oba be dani Chief Justice and na say obeso oba be dani a Supreme Court judge no at least odie onwo judge adwuma numu for at least odie 25 years. At least cases away dino any cases of national importance. At least what you say yempe clear benchmarks. At least onyo obi a wa publish it maybe book on the judiciary sector da. At what you say ene de me benchmarks na me ma. But ye say a bank should create a benchmark. And I think that this is good. And this will treat Sadiana President Ikufado ye na Okokofa get to talk on who virtually was a junior. Edeneba Supreme Court. Ono so ba no. E didn't send bebre by because now any seniors no omo in the cases biom. So bitterness bebre. And it was one of the downfalls of Gertrude Tokonu. Inti yepe clear defined merit benchmarks for the Judicial Council. Here we are. Nani bakrono will go through public vetting. Also the Chief Justice. The committee recommends the following qualification. The committee recommends that to qualify for appointment of a Chief Justice, a person must be a citizen of Ghana. Additionally, the person must be either a serving justice of the Supreme Court or a distinguished legal practitioner with proven expertise in law and at least 15 years of post-qualification experience at the bar without any disciplinary sanctions. It was said will be a person or babe than Chief Justice. Ye the benchmarks not to her. Onye Ghana ni onye obi a was serving as Justice of the Supreme Court with at least 15 years of experience. I say, appointment procedure. The committee recommends that upon a vacancy in the office of Chief Justice, a public notice shall be issued by the Judicial Council inviting applications from eligible persons. And I like this part of the committee, the Constitutional Committee review. I like this part because Mubahia get to talk on insenseme kosono. One of the things I'm making say, let us find a way of appointing a Chief Justice. Let us find a nice way of appointing a Chief Justice. A way be a year when say nipa kra wa obey and your president in san here so that oba than the Chief Justice are. Oh, who say president and them buy and me nkoye the president's bidding. Into the first one they say, see a person selected Chief Justice ye making sure say ye be declare the public. Say hey akwenya ba o say ye pe Chief Justice. Into wa ususu say obetumi aba than the Chief Justice no brana be peke forms. Also, the Judicial Council shall receive, review, and shortlist qualified applicants. The shortlist shall be submitted to the Council of State. Into Judicial Council, no, ebeye review. Okay, in Crawford saying yes, ye Chief Justice. Judges saying ena aba. Judges 10. Okay, ye share wamuni na background. Ye hine sefata. Ye he meet criteria no. Ye we are yen submitting list no enkonkoma the Council of State. Also the Judicial Committee of the Council of State shall conduct in-camera interviews and in consultation with the Judicial Council recommend 2 or 3 candidates ranked in order of merit. Into the Council of State no any nkrofo be ye interview as the woko adwuma ye interview no ne ne judges na ye interview. Ye judges ne ye interview ya na Council of State na nkasa to aba a select nkrofo mienu ene miensa bi. Also, the president shall nominate 1 candidate from the shortlist and submit the nomination to Parliament. Nti afei, ye de nkrofo no list no ebekwa akoma the president. Na president no choose baako no de akoma Parliament. Parliament shall by simple majority approve the nominee after a transparent vetting process. The president shall formally appoint the nominee as Chief Justice upon the approval. Upon a vacancy, a new Chief Justice must be appointed within 90 days. So this is the process. I mean, at the point in time, you see that the process still involves the president coming in and all that. But the truth of the matter is that this process being proposed no, is better than the old process I no. And that's the truth, right? Because it looks like the old process no, as a but way process now at least eligible people will fight for the position. What you say? But if do baby the Council of State will be bim, I see the politics doing that side and all that. But what I'm saying is that yes, this process at least is better than the old one. But see, if the nominee is rejected, the president may nominate again within 10 days from the remaining names in the shortlist from the Council of State. Qualification and appointment of other justices of superior courts. The committee recommends the following regarding the qualification of justices of the superior court, other justices of Supreme Court. Also, for the other justices of the Supreme Court, aside from the Chief Justice, the committee recommends that qualifications should be restricted to a practicing lawyer or a sitting justice of the Court of Appeal with at least 15 years of post-qualification experience at the bar without any disciplinary actions. If you perceive a selected judge eba Supreme Court at least only 15 years of judge why judge our Court of Appeal for at least 15 years. Oshe ye mame get to talk on one. Me sure say President Akufo-Addo the time no naka get to talk on be qualified so be Chief Justice. I'm not sure. I don't think get to talk on has spent 15 years in let me just ask AI. Let me simply ask AI. I don't think that we talk on I don't think that you talk on maybe did get through talk on spend 15 years at I don't think that we talk on spent 15 years maybe sir AI or see no get to talk on did not spend 15 years as a judge at the Court of Appeal. According to reliable biographical records, she was appointed a justice of Court of Appeal of Ghana in October 2012 and served there until her elevation in 2019. Inti get to talk on no survey 7 years at Court of Appeal. Inti wo ha nanka get to talk on sa new review yi ebaya enya dia nanka obetumi qualify po ababedane Supreme Court judge nanka mpese wababedane a year Chief Justice. And you see, that's what we say when we tell you say the appointment of Gertrude Kono as the Chief Justice no, it was a problem. Into say justices of the Court of Appeal. Remember, the committee recommends that to qualify for appointment to the Court of Appeal, the appointment must be a judge of a high court or a practicing lawyer with at least 12 years of post-qualification experience And okay. Don't get me. I think say the statement over here is ambiguous. It is ambiguous, and I think we need further clarification from the Constitutional Review Committee, because when they say that, say they get to talk on here example. When they say that a sitting justice of a court of appeal with at least 15 years of post-qualification experience at the bar, right? It could be two, in the sense that it could be say nipa krono a judge, but nipa krono I was say when you 15 years as that judge, and now say on say answer no be better than a judge crown na or your lawyer, and so bet to be about saying nipa krono a lawyer for 15 years, and so maybe that will qualify that person to intibia or your lawyer for 15 years, and waba be a judge for 1 year. Clearly maybe I say nipa krono so be qualified. I hope you understand. So I think that this statement is ambiguous. It's an ambiguous statement. Anyway, that's that. So basically, this is about the Supreme Court. This is about all that. If you have for me, comment box. That's it.